If you keep a firearm in this country, every assumption you had about the rules just got flipped on its head. A single federal decision that landed in December is rewriting the entire Second Amendment playbook overnight. 10 massive shifts are already locked in, and if you have not heard the details, you can break the law without ever pulling a trigger. Wait until you hear what number 10 now lets you do. An act that could have locked you up last month is suddenly 100% legal. Smash subscribe right now, because the next few minutes could keep you out of handcuffs. This is not speculation. The ink is dry and the changes are live. Law 1. Strict scrutiny standard. This is the keystone that props up everything else, so burn it into your memory. The Supreme Court has officially parked your right to keep and bear arms at the very top of the constitutional food chain. From this moment forward, whenever a bureaucrat tries to shrink that right, the government must survive the hardest exam in American law: strict scrutiny. That means 2 hurdles. First, they must show a truly compelling state interest, not a hunch or a slogan. Second, they must pick the narrowest, least burdensome method possible. You no longer shoulder the burden of proving why you should be free. They must prove why you should be less free. One sweep of this standard throws more than 400 federal gun rules into immediate jeopardy, and thousands of state-level restrictions are already being sued out of existence in courthouses from coast to coast. But most owners still do not grasp how closely the state has been watching them until now. Law 2. Qualified immunity removal. Any cop who tramples your gun rights can no longer duck behind the magic shield called qualified immunity. For decades, that doctrine handed officers a free out when they violated the Constitution. Today, if an officer ignores your Second Amendment freedom, he can be sued personally, prosecuted federally, and stripped of his badge forever. In Texas, 3 officers were just ordered to fork over $2.4 million of their own dollars after they cuffed a citizen who was lawfully open carrying. In Florida, a trooper lost his pension and is facing criminal counts for grabbing guns during a traffic stop without probable cause. Departments are now warning staff: violate gun rights and you personally pay the bill, not the taxpayer. Law 3. Seizure protection. But what happens when police try to disarm you without even bothering to arrest you first? The state can no longer grab your firearms by skipping criminal procedure. Red flag schemes that let a complaining neighbor cancel your Second Amendment status have been declared flat unconstitutional. Here is how the old game worked. Someone phones in a concern. Patrol cars roll up. Your guns disappear, and you spend the next year begging a judge to give them back. The December order is unambiguous. No arrest, no warrant, no charges, no seizure. Cops used to scoop up firearms and mumble possible evidence, even when no crime was charged. In the past 3 years alone, more than 12,000 guns were taken that way, and plenty were never returned. If yours were grabbed under red flag or civil forfeiture laws within the last 5 years, you can file for immediate return. Colorado has already given back more than 800 firearms in only the last 6 weeks. Law 4. Registry destruction mandate. Speaking of property, Uncle Sam has been keeping secret files he was never authorized to create. Every digitized gun owner file the feds have hoarded must be wiped forever within 90 days. This is one of the largest privacy wins in modern memory. For years, the ATF has been quietly assembling a searchable megalist of gun owners, even though federal statute bans a national registry. They have swallowed more than 920 million firearm transaction records, scanned them, and tagged them so agents can pull your name, address, or gun model in seconds. California, New York, Connecticut, and Illinois were all funneling data into that vault through sharing deals. The court gave the Bureau exactly 90 calendar days to deliver certified proof that every electronic record has been permanently erased. Miss the deadline or fudge the paperwork and the brass faces contempt charges, plus personal criminal liability. The FBI's background check computer has also been ordered to delete approved checks. Until now, they sat in the system forever. Bottom line, your lawful ownership data can no longer be collected, archived, or traded between agencies. Law 5. Digital privacy protection. Warrantless snooping on peaceable gun owners is now banned. For years, federal task forces tracked your phone every time you walked into a gun store, vacuumed your credit card history to see what you bought, and flagged internet searches like bulk 9mm or AR-15 2018 upgrade. Settlements are averaging 40 grand apiece. The court ruled that exercising a constitutional right is not probable cause for a fishing expedition. Your geolocation is off limits, your purchase history is sealed, and the NSA program that auto-flagged search terms such as concealed carry laws has been unplugged. If any agency wants your cyber data for anything gun-related, it needs a real warrant tied to an actual crime. More than 50,000 owners were under that microscope. Early class action settlements are averaging 40 grand apiece. Law 6. Carry permit standardization. Obtaining a concealed carry license just became lightning fast and dirt cheap. The ruling imposes 3 ironclad rules on every state: maximum 30-day processing, no requirement to show special need, and a $50 fee cap. Before the decision, New York was dragging applicants through 8 to 12-month ordeals. California was stacking $300 in fees. Right now, 47,000 New York applications that sat longer than 30 days are automatically approved by operation of law. Hawaii, which handed out only 226 permits statewide last year, has been forced to greenlight more than 3,000 in the past month alone. If you filed and the clock has ticked past 30 days, your permit is legally issued. Go pick it up. This is the largest single expansion of concealed carry rights in U.S. history. Law 7. Ammunition purchase freedom. Buying cartridges is now treated exactly like buying a hammer or a hamburger. States cannot bolt special hurdles onto ammo that do not exist for other retail goods. California's background check on every box gone. New York's ban on online sales and doorstep delivery gone. Connecticut's monthly purchase limits gone. The court recognized the obvious. A gun without bullets is a paperweight, and treating ammo like narcotics was irrational. In the last year, California ran more than 4 million ammo background checks. Today, retailers can sell across the counter with no extra forms, web vendors can ship nationwide, and bulk discounts are legal again. Online sellers report a 340% sales jump in formerly banned states, and roughly 2,800 dealers who quit ammo are reopening that side of the shop. Law 8. Gun business protection. Licensed dealers now enjoy the same regulatory fairness as any other lawful trade. For years, the ATF could yank a federal firearms license over a smudged serial number, a missing middle initial, or a date written 6/7/24 instead of 06/07/2024. That ends now. The Bureau may revoke a license only for an underlying criminal violation. Typos, formatting slips, and clerical goofs are no longer a death sentence. New FFL applications must be processed within 60 days, and home-based dealers who were chased off by zoning boards now have federal cover cities cannot use land use codes to outlaw a federally licensed business operating from a residence. Last year, the agency pulled 122 licenses for paperwork quibbles. In the 2 months since the ruling, new FFL applications are up 89% because entrepreneurs no longer fear arbitrary execution. Follow the law, and your livelihood is safe from bureaucratic vendettas. Law 9. Home and property rights protection. Federal officers may not step onto your land for a firearms inspection without a judicial warrant. Those surprise compliance raids collectors and kitchen table dealers lived in fear of are extinct. ATF teams used to knock unannounced, flash credentials, and demand to riffle through safes and bound books. If you balked, they threatened license revocation or a full criminal probe. The Fourth Amendment shield now applies with full force, no warrant listing specific criminal allegations, no entry. This blanket covers private collectors, home-based FFLs, commercial ranges, and every gun-related business. Over the past 3 years, more than 2,400 warrantless home inspections were conducted. Current settlement value averages $75,000 per violation. If an agent appears, the magic phrase is simple: show me a warrant with particular criminal allegations or leave the premises. Law 10. Interstate travel protection. You may now drive across state lines with your lawfully owned firearm without risking a felony trap in anti-gun territory. For years, gun owners mapped routes to avoid New York, New Jersey, Maryland, and Massachusetts, the way travelers once detoured around bandit country. Motorists were jailed at routine traffic stops when officers found a locked, cased, legally purchased pistol in the trunk. The new rule is blunt. If the gun is legal where your trip begins and legal where your trip ends, federal law protects you every inch of the journey, gas stops, meal breaks, even overnight motels. New Jersey alone arrested more than 800 such travelers in the past 5 years. Every one of those cases is being tossed. One New Yorker spent 2 years and $40,000 fighting a possession charge after a trooper discovered his licensed pistol in a locked box during a fender bender. If you are pulled over, recite this line: "I am traveling under federal interstate firearm protection."